Good afternoon and welcome to another edition of War Stories by the Beverly Hills Bar Litigation Section. I'm Rudy Lehrer, Chair of the Litigation Section. Today, our section is very honored to present Adam Streisand of Sheppard Mullin. Adam is one of the nation's top trial attorneys, particularly in high-profile litigation involving private wealth disputes, fiduciary litigation, business succession, and partnership disputes, as well as litigation involving trusts and estates and conservatorships. Now, City Wealth, Los Angeles Business Journal, and The Hollywood Reporter each have recognized Adam as a top litigator for celebrity estate disputes. Now, as in terms of those celebrity estate disputes, the list is impressive. Adam's courtroom battles have included the estates of Michael Jackson, Ray Charles, Marlon Brando, Michael Crichton, Anna Nicole Smith, Rodney Dangerfield, Dennis Hopper, William Randolph Hearst, and the list goes on. He's also widely credited for saving both NBA local teams, the Clippers and the Lakers. In 2019, Adam was named U.S. Trust and Estates Litigator of the Year by the Chambers. Today's session of War Stories will focus on Adam's trial victory for former Microsoft CEO Steve Ballmer against Donald Sterling. This resulted in Ballmer's $2 billion purchase of the Los Angeles Clippers. The victory relied on a rarely invoked clause of California's probate code, as Adam will explain. Today's moderator is Nicholas Van Brunt, a colleague of Adam's at Sheppard Mullin. Nick is also an accomplished trust and estates litigator. He is also partner at Sheppard Mullin, and he's team leader of the firm's private wealth services team. Before they begin, excuse me, two final announcements. For December 3rd, please mark your calendars for the next War Stories session featuring Neville Johnson. And in terms of program materials for today's session, they will be emailed out in the chat. And MCLE certificates will be sent shortly following the conclusion of today's program. Now, Nick and Adam, please take it away.
Hey, Adam, very nice to finally meet you. So Adam, before we talk hoops, can you give us a little background about your practice?
Sure. First of all, my thanks to Rudy and the Beverly Hills Bar Association. I'm honored that you chose me to talk today, and it's great to see my partner, whom I haven't physically seen in a couple of years. So a little bit about my practice. I've been a trial lawyer for more than 30 years. I started my career as an entertainment litigator and was very much enjoying being an entertainment litigator. I won the first digital sampling case, both in the trial court and in the federal courts of appeal for the Beastie Boys, a case that's taught in every law school in the country. And so all was well until a partner of mine came to me and asked me if I would work on a trust and estate litigation, a will contest. And my first reaction was, yuck, probate. I didn't even take it in law school. I couldn't imagine. And my partner said, look, trust me, you're going to love this. And I have to say that I was absolutely riveted from that first case. And it's been a passion of mine for many years now. And the reason is, well, first of all, as you know, Nick, we try a lot of cases, and I love being a trial lawyer. It's my passion. And so that really appeals to me. The legal issues are fascinating, but I'm a storyteller, right? That's what I do as a trial lawyer. And there are no more compelling stories than the stories of our relationships with our family. I mean, that's why worldwide literature is so rich in family disputes over estates. I don't watch Succession. I don't know if you do, but it's just too close to home for me. But that's what we do every day. So that's a little bit about my practice. One of the things I also really love about it is you have a bond with clients that is really unparalleled. They have lost really their family relationships. They're at very, very difficult times in their lives. And one of the greatest compliments that I get, and it's something that I hear often, is that I told their story in a way that they didn't think was possible. They certainly couldn't have. And they were so proud to have me tell their story. And it means a lot to me. And I become really close to my clients, and they stay very close with me over many years.
It's funny that you bring up Succession, because when people ask me what my practice is, I refer them to that television show. So given the many different stories you've told over the years on behalf of clients, why'd you choose to speak today about the Sterling case as opposed to one of your many other trials?
Yeah, I mean, there are so many from which to choose, but the reason I wanted to talk about the Sterling case, or I chose to talk about it today, is it's a case that really mattered to me, right? I wanted to be the guy that took the Clippers away from Donald Sterling. And we'll talk about why, right? And also because it is a case that shows that strategy can be everything, because it was strategy that won this case, and won this case quickly, a strategy that was my strategy, and that, you know, we'll talk about. So that's really why I wanted to talk about it. So just to give you the backdrop, in April 2014, TMZ released an audio tape of real estate mogul Donald Sterling engaging in a conversation with his mistress that he thought was private, but she was taping. She, the now infamous V. Stiviano. And what he said on that tape was absolutely horrifying. He said, quote, "It bothers me a lot that you want to broadcast that you're associating with Black people. Do you have to? You can sleep with Black people. You can bring them in. You can do whatever you want. The little I ask is not to promote on that," speaking of social media, "and not bring them to my games. I'm just saying, in your lousy fucking Instagrams, you don't have to have yourself with walking with Black people. And don't put him," speaking of Magic Johnson, "on Instagram for the world to have to see. And they have to call me. And don't bring him to my games." This tape, which was released, is horrifying. President Obama was in Malaysia. He was asked in a press conference to comment on it and said it was incredibly offensive. Obviously, it was getting huge attention, the attention it deserved. The NBA commissioner, Adam Silver, took pretty bold and swift action. He removed Donald as the controlling owner of the Clippers and installed on an interim basis as a CEO, Dick Parsons. Dick Parsons was a highly respected African-American former chief of Citigroup and Time Warner. And Adam Silver also banned Donald Sterling from basketball, threatened that the NBA would seize the Clippers from him and sell it if he and his wife, Shelley Sterling, didn't take action themselves to sell it. And the NBA owners, interestingly, of course, many of them condemned the comments, but there were really decidedly on opposite extremes about how they felt about this whole situation. Because there were owners who felt that the NBA was overstepping its boundaries by they're going to take a team away from an owner in circumstances where this was just pillow talk, right? And I can tell you from my conversations with the NBA as this was going on, they didn't want to have to do it, right? I mean, they were in a very difficult spot. And so they viewed my role as a way of sort of rescuing them from a very difficult situation. And, the situation for Donald didn't improve after the tape came out. The NBA conducted an investigation which revealed that Sterling had asked Stiviano to lie to Barbara Walters and tell Barbara Walters on national television that Stiviano had altered the tapes and that Donald had never said these things. He then made the brilliant move of going on Anderson Cooper, right? And what he said to Anderson Cooper was pretty fascinating. He said, quote, "I've never been a racist and I'll never be a racist." And he then said, "It's Stiviano who brought up Black guys in their little tete-a-tete that was recorded." He called Stiviano a street person. By the way, she's a woman of color. And then he said, "I don't know why the girl made me say those things," which, even if that were true, what a strange admission, right? I mean, was he suggesting that he isn't racist, but he suffers from such diminished capacity that he was easily manipulated to express racist thoughts that Stiviano had planted in his head, right? Something that we were able to use. And then he went on this crazy rant about Magic Johnson. He acts so holy. He made love to every girl in America, and he got AIDS. Actually, Johnson has HIV, not AIDS, but I didn't criticize him. I could have. Is he an example to those children? So Anderson then tries to steer the conversation in a different direction. And Sterling goes right back at it. What has he done? He says about Magic, right? And Anderson Cooper starts to say, well, you know, he's a successful business person, and Sterling cut him off again. He's got AIDS. I think he should be ashamed of himself. I think he should go into the background. And then he broadened the attack by saying, you know, we Jews, when we get wealthy, you know, we help people. But he says, quote, some of the African Americans, they don't want to help anyone, end quote. Okay. This is, you know, in the backdrop of what's going on. Cooper then said, you know, trying, I think, to change the subject, said, you know, do the owners support you? And Donald said, of course the owners support me. The players don't hate me. The sponsors don't hate me. The fans don't hate me. It's the media that hates me. And so when Cooper pointed out that some players had threatened that they wouldn't play if Sterling remained the owner, Sterling finished off the interview by saying, I contend that they love me. They know I'm not a racist, right? Magic then went on Anderson Cooper. He sort of felt compelled to respond and explain how disturbing and sad it was. You know, I had dinner with Magic after I won the case for Jeannie Buss and secured her control of the Lakers. And it was a really interesting conversation. I got to know Magic. He's a man of faith. He's done an enormous amount for the African-American community, for people in the HIV and AIDS community, but of course he doesn't publicize this stuff, right? So, there we had the backdrop of the situation. That's what I knew about the situation, you know, before I got involved. And this mattered to me. Of course, at the time, I had no idea that it was going to soon matter to me in a really personal way. But one thing I want to say, too, is, and I said this to the press all throughout, you know, multiple commentators from people inside basketball, pundits, talking heads in the media, NBA owners were saying, well, you know, these were conversations that were intended to be private, right? You know, they shouldn't be threatening to take away his team for things that he intended to be private, you know. And that really rankled me, right? Because the fact that he intended his racism to be private, to me, is of no moment. I'm glad, you know, it got exposed.
Yeah, as you know, I'm a sad Clippers fan year after year, and so, you know, it was horrifying to see all that play out for me as well. So I think it was personal for a lot of us, and, you know, I appreciate your touching particularly on the irony of him saying that, you know, taking exception with members of the African American community not helping one another when Magic Johnson is an incredible example of someone who has helped, you know, various communities. So that's the stage. How do you become involved in this?
So, as you know, I was a big cyclist. It was a Saturday. I just finished a big ride, sweating up a storm in my cycling kit, and noticed that I got a call. And it was a pretty cryptic call from a partner at Covington and Burling, simply saying that they had a high-profile matter that they wanted to talk to me. So I returned the call while I was still standing there sweating. And I talked to a partner there at Covington and Burling who was representing Steve in an attempt to acquire the Clippers, and told me that the Sterling Family Trust, which was a trust established by Donald and Schelling that held their community property, including the Clippers, had entered into negotiations with him to sell the team, but Donald, who had originally supported the sale, had changed his mind. What I learned about what had occurred before my involvement is that Donald had actually allowed Shelley to have two psychiatrists evaluate Donald. One was Merrill Sue Platzer, and the other was James Edward Spar. And Donald's lawyer, Bobby Samini, sat in the kitchen while Donald sat in the living room with each of these psychiatrists and sat to be evaluated. And one of the issues that you and I deal with a lot is levels of capacity. And the research shows that even when a person has mild cognitive impairment, they can lose frontal lobal or executive functioning, which controls your logical reasoning. So even if you have capacity to do lots of things, including making a will and maybe even revoking one, we'll talk about that, you may not be making rational decisions, particularly rational decisions about managing assets worth billions of dollars. And that's what these psychiatrists had concluded. I mean, Exhibit A, of course, was, even beyond these evaluations, was his diluted rants on Anderson Cooper. Exhibit B was sitting down for these evaluations at all. And I wish I knew, I don't know, whether Donald's lawyers tried to convince him not to do this and they couldn't control him, or somehow everybody thought this was a great idea. He was going to prove that, there was nothing wrong with him. But whatever it was, it walked right into Shelley's hands, into our hands. So Donald actually recognized the NBA was coming after them. He allowed Shelley to conduct a closed bid process for soliciting bids. And they got 3 bids for 1.2, 1.6, and $2 billion, right? $2 billion being Steve Ballmer. No one had ever paid that kind of money for a sports franchise in history. Meanwhile, Donald, who had originally supported this idea, he then files a $1 billion lawsuit against the NBA. But his lawyer, Bobby Samini, publicly announces that Donald has agreed to sell to Ballmer and to resolve all issues with the NBA, but just as quickly completely undermines his lawyer and says that he'll never sell, right? Again, other conduct that just isn't very rational, right? So Shelley invoked a process under the trust to remove a trustee. And under their trust agreement, which is a contract between the two of them, it provided that if 2 psychiatrists who generally make these kinds of determinations in their practice certify that a trustee does not have capacity to be trustee, they're removed. End of story. So that's what she did. She signed the contract with Ballmer. And then on that Saturday, I got the call from Scott Rhodes. Scott Rhodes explained to me that Shelley's lawyers had laid out a plan where they were going to serve Donald with a notice, what's called a notice of proposed action. And that then would allow Donald 30 days within which to object. And all he had to do was send a letter and say, I object, okay? And if he had done that, Shelley would have then had to file a petition to try to approve the deal. They'd be in litigation for years. So I said to them, look, I got a better idea, okay? My idea is that we use, and again, I'm still sort of like, sweating in my cycling kid, and here I am having this conversation. We use this provision of the probate code that has never been used. There's one case in which it was a conservatorship situation in which they wanted to make a tax change to the plan, and they wanted to make sure that they could do that before he died. It's the only even mention of it. It's probate code section 1310B. By the way, the Clippers afterwards gave me a jersey with the number 1310B on it, which is hanging in my office, which I really like. 1310B is a really strange provision because it provides that if the court makes a decision to instruct a trustee to take a certain action, if the court finds that there's an immediate risk of irreparable harm to the trust, if the trustee doesn't take that action, the court can instruct the trustee to take that action, even if there's an appeal pending. Okay. Now, you can appeal whether that was, the propriety of making a 1310B order, but the trustee can be instructed to take action even if there's an appeal pending. So I said, look, we go in on an ex parte basis, ask the court, given the circumstances that to approve this sale and to give us a 1310B order. So even if Donald appeals it, the transaction go forward. So the lawyers are pretty stunned. This is a very different advice than they were getting from Shelley's lawyers at Greenberg Glusker. They asked if they could get Steve on the line. So got Steve on the line and told Steve the idea. He said, wow, that's incredible. Will it work? And I said, look, it's a statute that has almost never been used. So it's clearly a long shot. But here's why I think it's going to work, right? I mean, we're in an unprecedented situation with the NBA threatening to seize this team from a trust, and the court has an obligation to try to protect the trust and its beneficiaries. And so, yeah, I can't show you any precedent that says it's going to work. I believe it's going to work. So we get on the line then with Pierce O'Donnell, Bert Fields, and Mark Stern, who's a trust and estates lawyer at Greenberg Glusker, who are representing Shelley. And I explained to them in the most diplomatic way why I don't think the notice of proposed action idea is a great idea. And I explained to them the strategy of going in ex parte, seeking 1310B relief. Pierce, who is a civil lawyer, doesn't know anything about trust and estates, turned to Mark Stern and said, what do you think? Mark said, I've never heard of 1310B, but it sounds great to me. In fact, a lot of the legal press afterwards interviewed practitioners, specialists in the area, professors, all have said, didn't even know this existed. Pierce then asked if I could provide a sample ex parte for 1310B relief. Of course, I'd never done it before. Nobody really had ever done it before, but I told him I'd write the papers. So that was June 7th. And on June 11th, we walked into court on an ex parte basis and asked the court to give us as quick a trial date as we could. And the court gave us a trial date of July 7, 2014. So less than 30 days, we're going to be in trial. That's how it began.
So you go in for the ex parte, you get the trial date. What was the reaction from Donald Sterling's side?
So what I learned was that we were in court on ex parte on June 11th. Actually, on June 9th, which is my birthday, I guess it was a birthday present, Donald signed a document revoking the trust. Now, the trust was revocable. He could revoke it. And by the way, we certainly didn't want, for reasons I'll discuss later, we didn't want to have a battle over his capacity. And I'll talk about that a little later. What the capacity is to revoke a trust is not very clear, but he probably undoubtedly had capacity to revoke the trust. And that would mean that the Clippers and all the other assets would revert back to each of them, Donald and Shelley, as their community property. And no longer would the probate court have jurisdiction, this trust wouldn't exist any longer. In fact, Judge Levanis, our judge, said, to me, Mr. Streisand, isn't this the elephant in the room? And I said to him, Your Honor, it's a mere mouse. And I'll get to that. I'll explain, just give me an opportunity. I'll explain to you why it's a mere mouse. Now, I knew that we were in unprecedented territory here again on this issue of what happens now that the trust is revoked, right? But I wanted to tell the Donald Sterling story first before we got to the really difficult and unprecedented legal issues. So I just kept saying, it's nothing, it's a mere mouse. He was even asked about it by the press. Hey, the judge says, it's nothing, don't worry, I'll get there. And at the end of the trial, then it was my job to clean that up in closing argument.
So speaking of closing argument, let's get to your role at trial.
Yeah.
What was your role?
So
yeah.
First of all, it was a great collaboration with Shelley's lawyers, Pierce O'Donnell and Burt Fields. We tried the case together. I did a lot of the heavy lifting on the most difficult legal issues and factual issues, and continue to shape the strategy as these stumbling blocks were thrown our way. It was interesting because Donald's lawyers challenged my standing to even appear or participate because I was representing Steve Ballmer, right? Ballmer is not a trustee, he's not a beneficiary. Given recent case law, I probably wouldn't have won that issue, but the judge said he thought that my involvement in my role would be helpful to him. So as a, quote, interested person, Ballmer having an interest in the transaction, he allowed it. Now, what Donald's team didn't know and still doesn't know until I tell him right now is that Pierce O'Donnell had in his briefcase a document to associate me as co-counsel for Shelley in the event that the judge said I couldn't participate for Ballmer. They wanted me to try the case with them. They were determined that was going to happen. So even if Levanas had said, hey, Ballmer has no role here, Streisand, you have no role here, I would have been co-counsel for Shelley in the case. So I had devised the strategy for bringing the case to court quickly and putting us in a position of being able to get this done, even if there were an appeal to the decision. And then it started to influence how the trial progressed in sort of important ways. I already talked about the revocation issue was a big issue. 1310B, it was my job to carry the burden on that. And I'll talk about that. And then the psychiatric experts, that was a big issue. So as I mentioned, we had two psychiatrists who had evaluated him and determined that he lost capacity. Well, the other side wanted to call their expert psychiatrist or psychiatrists to refute that and say that he has capacity. And I said, well, Your Honor, I made a motion to eliminate and said, hold on just a minute, okay? Your Honor, you could line up psychiatrists up and down Wilshire Boulevard from here to the ocean, and they all might have different opinions, but it doesn't matter, right? Because this is a contract between these two people. And all it says is that if you have to, this is what they agreed to in terms of how to deal with a trustee who might be losing capacity. If you have two who say he doesn't have capacity, that's it. That's the end of the story. So as long as their evaluations were appropriate, it doesn't matter whether somebody has a different opinion. And the judge agreed with me, and we were then able to short circuit the other side's ability to offer, every time they tried to offer testimony about his capacity, they were shut down. And that was really key, really important, because when it came time to dealing with the issue of whether or not he was properly removed and she had the authority, they couldn't put on any evidence other than trying to poke holes in our experts, which they couldn't do. So that was my role. In closing argument, so Pierce and I divided closing argument, and he had the sort of the removal of trustee part and the valuation part. I had to deal with the fact that the trust had been revoked, and the 1310B issues in closing argument. So I wrapped up our presentation.
So now that we have the arc, let's get a little more granular. So what are some highlights from the trial itself?
Well, one of the moments that I have to admit was fun was, so Burt Fields was cross-examining Donald, which frankly was really, ended up being sort of an argument by, two old ex-prize fighters. I mean, but anyway, Donald gets off the stand after Burt's cross-examination and walks past Shelley, and loud enough, and we're a counsel table, loud enough for us to hear and loud enough for the judge to hear because he commented on it. he walks past Shell and he goes, "Pig," which I think really helped his case.
Yeah, I was actually sitting next to Shelley that day in trial. It was an awkward moment, but it was one that I knew that was going to be probably pretty good for us in the long run. But yeah, it was quite a moment.
Yeah.
Yeah.
You know, of course, the sort of winning the argument about the experts and making sure that we could, you know, that we could focus on just our expert testimony and blocking them from the ability to counter that, because it's difficult, right? I mean, he was mildly impaired, right? He clearly had some issues about his logical reasoning. I think that was pretty clear. But then again, no doubt they would have been able to present evidence, that they would have presented evidence that he has capacity and so on and so forth. And we didn't want to get into a battle of experts. That's why also, you know, we didn't challenge the revocation on capacity. We didn't want to fall into the trap of opening the door of letting them sort of, you know, have a battle of capacity. So I had to deal with the revocation issue in a very different way. So the fact that he had revoked the trust, what I relied on to argue that Shelley could continue to follow through on the contract to sell the Clippers as trustee, even though the trust had been revoked, was a provision of the probate code, another one of these provisions of the probate code. In this case, there's no law, absolutely no law on it, no cases, but there is a provision that says that after a trust terminates, the trustee has reasonable authority to wind up the affairs of the trust. Now, whether going ahead and selling a $2 billion basketball team is winding up the trust affairs, not an easy one, especially with no authority to support it. But I made the argument that it was necessary, particularly because it would have created all kinds of liability issues, not to mention the NBA was waiting in the wings and could have seized the team if she didn't have the authority to wind up the trust affairs by executing on a contract that she had signed. I had to carry, as I mentioned, I had to carry the burden on 1310B. And the way I did this was I called Dick Parsons to the stand. Dick Parsons is now the interim CEO of the Clippers. And a very impressive guy. But what I needed him to do was to testify about all of the ills that had befallen the Clippers as a result of Donald's actions, right? So we talked, when I prepared him for his testimony, we talked about the fact that, you know, sponsors had said they're not going to sponsor, right? Players have said, we're not going to take the court. Coaches, including Doc Rivers, said, hey, we're not coaching. Now, the problem was none of them wanted to testify, right? They didn't want to get involved. So I needed to try to get all of that in through Dick, right? So we had some real evidentiary issues. And of course, they were quick to it. But I had my theory for how being the interim CEO and trying to evaluate the circumstances and his state of mind and valuing the team and so forth. And we were able to get it all in. But one of the great moments, you know, was when I was preparing Dick is, you know, we were talking about all these things. And then he sort of, you know, offhandedly said, yes, you know, we're in a death spiral. I said, wait a minute. Okay. That's the money, Dick. That's the money, right? You need to be able to say that when we, and right at the right moment, right? For its dramatic effect, because it really is dramatic, right? But, you know, one of the things, you know, love being a trial lawyer, right? People always say cross-examination is the hardest thing about being a trial lawyer. I think that's nonsense. Cross-examination, if you do it right, cross-examination shouldn't be that hard, right? Because it's your job to control the witness, right? If you have control of the English language, you have control of your case, you ought to be able to control the witness, right? And you just want the witness to be, you know, a monkey on the stand who's just going to confirm what you need to confirm. You get in, you get out. You know, you beat the witness up if you need to beat him up. You coax him along if, you know, if there are things that he can offer to help. That's not so tough. Direct examination, a good direct examination, that can be really, really hard, right? It needs to be a conversation, but it also means I can't lead him, right? I couldn't say to him, so are you in a death spiral, right? Okay, so I needed to be able to engage him in the conversation so that, and look, you know, witnesses, even the best witnesses can go off the rails. They may have been great in preparation. They're terrible on the stand. They say things that you didn't anticipate or expect. They say things that contradict the things that they've told you or contradict the evidence the written evidence, right? So, you know, it's important, obviously, to prepare witnesses, right? Although not over prepare, because it has to be natural. And I had a witness I prepared, and he started to tell a story and he started to break down, and I said, I'm not going to talk about that anymore until we get to trial, because I figured if we had practiced that, then by the time I asked him at trial, it was going to be just sort of matter of fact, and it was going to lose all of the emotional force. So I just hoped that when we get to trial, it would be that way. But I really feared practice. So it's a delicate balance of how to do it, but direct can be really, really tricky, and a good direct, a real conversation can be, you know, incredibly effective. And then, you know, again, for me, the closing argument was, again, another big highlight. I mean, Dick was great. Closing argument, sort of bringing it all together for the court, you know, was really, really a meaningful moment for me.
So in the closing, you know, they had that part about removal. They had that argument, yeah, but they didn't have the access to the medical evidence because of the motion in limine. So tell me about how you dealt with that at closing.
So again, we reinforced in closing argument that, hey, it doesn't matter it doesn't really matter what his capacity is or it is. It doesn't matter what people think it is. It doesn't matter what the opinions are. What matters is they entered into a contract. The contract was fulfilled. These are two well-established, well-known experts. They reached their evaluations. That's all that was required. And that's the end of it. Okay. And there's no contesting that. So that's, you know, that's how we dealt with that, you know. Closing, of course, is, you know, we all live for the closing, right? I mean, you know, by the way, I think opening is just as important. You know, I always try to find ways to be the plaintiff, even when I'm not, but I try to be the plaintiff so I can go first, right? One of the things that always surprises me, and maybe as I get older, I'll learn why this is a good strategy, but is when I have opposing lawyers who defer closing or defer opening until their case. And I think that's great. I mean, now you've given me a chance to frame the story, to tell my story, and then start to get the evidence in that I want to get in before the judge or the jury knows what it is, how the fact finder ought to be thinking about your case. And I get it that they think, well, they want to see my case first. Well, you know what? You ought to know my case. Right? I mean, preparation is the key to success, right? And then you ought to know, I mean, maybe not everything, but you ought to know my case before the trial begins, right? So I never really understood that, but you know, I had this great moment. You know, I was trying this case in New Jersey, and the judge hated my client, hated our witnesses, hated our case, and I don't think he thought very highly of me. Because every time it was my turn, he'd say, California, cross-examination. So I'd get up, and my client, you know, one of these larger than life people, there's some, you know, talk about preparation. There are some people you cannot prepare, no matter what, you know, and I tell witnesses, I'm the guy who's going to win the case. You got to trust me to do that. Your job is to just let me help you tell the story, right? Don't try to win the case from the stand. Well, my client not only tried to do that, but, you know, he told a lot of tall tales while he was doing it. And during a break, we go into the jury room, and my client's pounding the table, you know, you're doing a terrible job, the judge hates me, and so on. So I'm thinking, well, if you'd stop lying, and making yourself out to be a despicable human being, maybe things would go better for you, but okay. So we get to closing, and I realize this is it. I got one shot. And so, as my client would tell anybody who would listen for years to come, it was like watching a movie. I mean, he said, you brought the house down. We get to the end, I get to the end, and the judge says, I didn't know I was going to do this. I believe that Mr. Streisand's client lied about everything, except I agree with Mr. Streisand that he told the truth about the most important facts that on which this case turns. And I think, and so I agree, and we won the case. But so, you have those moments, right? That, you can win it on closing, but, hopefully you don't have to be in that situation.
So speaking of closing, so closings are done. You've gone through trial on this very expedited basis, lots of, intricate legal issues. It must have taken Judge Levanis a long time to come up with his decision after the case, right?
Well, his decision was pretty swift in our favor. But, as you know, in a bench trial of that duration, he can't just simply sign his statement of decision. He's got to wait 15 days, right? So, of course, we're counting the days, right, until that 15th day when he can sign the decision. Now, I wasn't going to just sort of sit around and wait to get it in the mail, okay? So on the day in which the judge is allowed to sign the statement of decision, I went to court. There was no reason for me to be in court that day, but I went to court. And I walked past my opposing counsel, who was in the hallway waiting to go into a different courtroom for a matter. Hey, how are you, Gary? I walked into Judge Levanis's courtroom, and the clerk looked at me, nodded, walked back into chambers. A few minutes later, he walks out and he hands me the signed statement of decision. Now, I'm the only one who knows it exists. I'm the only one who has it, okay? So I put it in my briefcase. I walk out of the courtroom. I walk down the hall. Hey, Gary, see you soon. I walk out of the courthouse, and then I jump on a conference call because I had the NBA, Bank of America, Steve Ballmer and his transactional lawyers waiting on hold on a conference call to see what would happen when I did this. So I get on the call and I say, I have the decision in my hand, close. Because of course I'm worried that they're going to go in and seek an emergency appeal because as I told you, they can appeal the propriety of the 1310B, right? The 1310B says, trustee, go and do it, go sell the Clippers, even if there's an appeal, but they can appeal whether that is an appropriate order. So I knew, of course, they would do that and that they would be ready to do that. So I get on the phone, I say, close. And Steve says, whoa, wait a minute, are you sure? Well, I guess it's his $2 billion. He had the right to ask me if I was sure. I said, I'm sure, took a picture of it, I texted it. And the person at Bank of America said, okay, executed, $2 billion is transferred, and the team was his. Of course, very quickly, the other side realized the statement of decision had come out. They filed an appeal, and the Court of Appeal dismissed it and said that it's moot. The team's been sold. They were able to appeal for some reason, they pursued the appeal of the underlying decision, which I guess if they had gotten it reversed, they could have claimed damages on a $2 billion settlement. Of course, our experts testified. There are no metrics that could explain a $2 billion sale of the Clippers, much less any sports franchise at the time.
Right. So, against that backdrop, can you share with us, some of your feelings about what it means to you to be a trial lawyer?
Yeah. So, first of all, obviously there are great moments like this, right? Look, you're a trial lawyer because you love to win, right? Hate to lose. But look, you're gonna lose trials. One of the things that I always say, we've talked about it after we've tried cases, that I say I'm so proud of the way we did this. I know that we did it to the best of our ability, that we were intellectually honest about it, we were ethical, and whatever happens, I feel good about that. And particularly one of the things that I love, being a trial lawyer is a science, right? You can learn the science, right? But it's also an art. And it's a craft that you have to hone over years and experiences of being in that chair and sitting through those trials and taking witnesses and making arguments, and getting rulings. And one of the things that I love, of course, is going up against really great trial lawyers, right? Because anything that helps me to elevate my art, right, my craft, it is just such a fulfilling experience, So yeah, okay, maybe it's not as good as winning, but it's pretty darn good. I've had crazy cases, right? As I mentioned, with these kinds of cases, all kinds of fun. I mean, we had the attack on the trust because our client, unbeknownst to us until the case was filed, was a bigamist, right? She had never been divorced from her first husband. The claim was that she defrauded him, blah, blah, blah. And I was able to investigate, construct this theory, and persuade the court to non-protunct her divorce back 22 years, as though the divorce had happened 22 years ago and invalidated the marriage. And as a matter of fact, the IRS wrote us a check for $100 million after we validated which was just a partial payment on the estate tax. And speaking of bigamy, right, we had our double bigamy, right? She was married to three people at the same time. And then, one had died in a car accident, one had died drugs. And you said to me, well, you should tell the judge, but Your Honor, what's the problem? She's been bigamy free since 2015, which was one of the greatest lines. We had the guy who had a baby with sort of a Chinatown situation, had a baby with his brother's wife. So his baby was his son and his nephew. The witness who, I flew down to Key West to take the deposition of a witness, the person who was supposed to be the star witness. And hey, by the way, this isn't your real name, Robert. You changed your name, right? Because you were convicted of killing your husband with rat poison, right? Had lots of cases with, proving somebody was the baby of a celebrity, somebody wasn't the baby of a celebrity, Michael Crichton, Barry White, Ray Charles, Marlon Brando, and just fascinating cases like that. And we've had some fun with experts too. Remember we won that $25 million trial down in Orange County. And the other side wanted to call a retired judge, right? Judge Jackson, right?
Jackman.
Jackman.
Yeah.
Wanted to call a retired judge, right? And I took the guy's deposition. I just listened. Okay, that's what you're going to say. Okay, and I just waited. Didn't make a motion in the minute. When they called him, I asked to voir dire, right? And I played his videotape deposition. So your area of expertise is what? Well, it's much like the judge in this case. I'm going to apply the facts to the law and render a decision. Because I knew smoke would be coming out of the judge's ears as it was. And that guy's I wasn't going to say, hey, you can't call this guy. Call him to the stand. Right? Or we had, go ahead.
Well, I was going to say, I think that's a good example. And in that same trial, there's another example of this idea that sometimes it's more important to know when not to fire the gun than when to fire, right? And there was another expert in that same case who was the sort of accounting / damages / size fits all. And he just went on for days and days. And I remember that was a pretty junior lawyer then, and I spent days preparing all the different avenues for cross. And so we were really ready to go. And I remember after he was up there, you just getting up and saying, no questions.
That's right.
Because it was all irrelevant. And it was a great lesson for me. Like, you got to be prepared, because who knows what's going to come out of his mouth.
Right. Yeah. Sorry to take that opportunity away from you, but yeah, no, it's absolutely true. I mean, absolutely true. I mean, that was a moment. You got to know when to stop too, right? I mean, cross-examination, you know, maybe if you watch the Rittenhouse trial, I mean, you know, you got to know what it is that you need to get and how you're going to get it and get out and sit down and make sure that you know, it's you know, you've got as much drama as you can build from it. Don't bore people to tears. And, you know, as a lawyer used to say, you know, no chicken shit cross-examination, right? I mean, stick to the big stuff, stick to the themes, stick to the things that you need. And yeah.
Yeah, because that's the thing. When, you know, I mean, there's obviously jury trials, and then in probate, a lot of our trials, you know, are bench trials. So, you know, you've got this one fact finder there. And if you do a cross-examination that's cogent and focused, that's the thing the fact finder is going to remember. If you've got this long-winded, you know, sort of punishing cross, that may be effective in some ways, but you got a judge who's sitting there, they've got 50 other matters on their morning calendar, right? And so it's really important to get in there, as you're saying, I think, just to focus, you know, on the important.
Yeah, I had a cross-examination, you know, of the other side that was pretty withering, that ended up rather tragically, right? So I represented a brother against another brother. And you know, the other brother, you know, call him Steve, he had procured an amendment to his mother's trust that gave him everything rather than 50-50 with my client, as had been the plan previously. So anyway, I get the guy on the stand and tear the shit out of him. Okay. And by the way, you know, like I mentioned, I mean, a trial lawyer needs to have lots of different speeds, right?
Right.
Some people deserve to get the shit kicked out of them, and you ought to do it. And some people, you ought to be, you know, take it very gingerly, you know, whatever, get what you need. And, you know, it's not, because they're, you know, they're witnesses you don't want to beat up, right? It's not a good look, but you got to be able to know the audience and to adjust and so forth. Anyway, judge invalidated the amendment. So my client now was going to get 50-50 of the estate, as we contended he should get. So Steve gets on his motorcycle, drives up Mulholland, drives off of Mulholland, kills himself, and he dies intestate. He didn't have a will. And his only heir was my client. So my client ended up getting 100% of the estate. So we were there to fight for 50, but you know, we've had moments like that. You'll remember we won trials where we won damages and double damages for tens of millions of dollars against a guy. You auctioned off his car. I mean, we tried to convince the guy, hey man, just stop, right? And we kept having to go, and, you know, one trial after another, you know, multi-million-dollar judgment, another multi-million-dollar judgment. Now we're like, you know, I send you to go auction off his cars, hoping he'll stop. He doesn't stop. Finally, the sheriff had to take the rifle away from him when we took his house. He was sitting cowering in his house. Those are not the, you know, most. But on a lighter note, I don't know if you remember this case. I call it my cross between As Good as It Gets. If you remember that movie with Jack Nicholson and Helen Hunt. This misanthropic, you know, guy or whatever, who goes into the diner all the time, and then the other movie, As Good as It Could Happen to You, right, with Nicolas Cage and Bridget Fonda, where she's a waitress, he's a cop, he goes in, he doesn't have a tip to leave her, so he gives the lottery ticket, you know, and then Rosie Perez's wife is all mad because he's promised half the lottery winnings to this waitress. Well, so I represented a waitress at a diner. She had a client who was much like this Jack Nicholson guy, but this guy was illiterate. He was a total misanthrope, sexist. He would just blurt out these, sexual comments of waitresses and so forth. But he would go into this diner at 5 o'clock in the morning every morning, and she would pour him black coffee. And she unlike all the others, she would, take his stuff and give it back to him and whatever. And she'd talk to him and whatever. But she didn't think much of it. He dies with lo and behold, an 8-figure estate in which he's left half to her, the waitress. And she walks into my office and said, if I had had any idea that, I meant this much to the guy pouring him black coffee at 5 o'clock every morning, I kind of would have done something else. But the family was not too happy that she got half the estate.
Yeah. Yeah. Sorry, go ahead.
No, I was just going to say, I think we're probably.
Yeah. Well, and I think that sort of encapsulates what's so interesting about trying our particular types of cases, because the stories are just always juicy, right? I mean, they're the kinds of, they're juicy, and there's also, heavy emotions involved, and it really matters to people in a personal way that's different, than a lot of cases. And so,
and that is one of the great things. I mean, I always wanted to be a trial lawyer, not a litigator. I want to try cases. And it's great to be able to know, because I try cases, what the litigation process really is like, how to use that process to be a trial lawyer, not to be, a litigator, trying to make somebody's life miserable or whatever. And I also think, when you try cases, you develop relationships with your opposing counsel. You can't, the letter writing that serves no purpose except the ego of the lawyer, and it makes it expensive and doesn't advance the ball. When you try cases and you're in there and you're going at it, right? And and that lawyer makes some great argument or some great examination, and you've got to stand up and match it. You develop a real respect for each other. And it's one of the great things about being a trial lawyer.
Not to bring it back to hoops as we close, but it's not dissimilar than the fraternity in the NBA, right? Of these great players who respect one another and bring out the best in one another. And, ultimately, somebody wins and somebody loses, but there is that mutual respect. And that's because it's a profession in the same way,
Should be.
Yeah, it should be, right.
Yeah.
That's what we aspire to. Yeah.
Yeah.
Well, I think we're coming up on the hour. I believe my charge at this point is to tell everyone that the CLE credit will be forthcoming in the not too distant future. And we'd like to thank the Beverly Hills Bar Association and their sponsors for having us today. And I think that's a wrap.
And thank you, Nick.
All right, it was a pleasure. Thank you, Adam.